Good morning, ma'am. You're Crystal Julian.
Yes, ma'am.
And so Ms. Julian was previously in court and entered a plea of guilty to burglary of a building, which is a state jail felony that was in.
Right off the bat, this case is serious burglary with an enhanced charge means prior history is already weighing heavily. But here's the twist, instead of straight prison time she's getting a probation deal. The real question is, will she actually be able to stay out of trouble this time?
And the agreement was for a 10-year term in prison, probated for 10 years with restitution to be determined. There were some issues. Looks like I reset.
It was positive last time.
Right. And so I raised the bond, reset it for a couple of weeks, got a substance abuse assessment done. In the meantime, did everybody get a copy of that substance abuse assessment?
Did you?
Okay. Did you not?
I didn't, but I defer to the court on that.
Okay, yeah,
I'm saying you didn't, I just,
It's okay.
sometimes they slip through, sorry.
that's okay. So y'all have all been able to review the pre-sentence report, correct?
Yes.
Is there any reason not to go forward with sentencing at this time?
No, fast change.
Judge, obviously the state is aware of the court's concern about her criminal history, just so that you know, the co-defendant was sentenced to significant prison time in this case. I believe he was actually the one more culpable based on the facts. I've also reached out to the managers of the storage facilities in an attempt to gather a restitution amount. Obviously, her offer was made with the enhancement in an attempt to reclaim or regain that restitution. They were unable to provide me with that. I also reached out to the detective with respect to their attempts to contact all the individual owners, and I didn't receive a word back from that. It's my thought that probably they recouped those losses off their personal property insurance.
Okay. Okay. So do you have any input as to the recommendation under that substance abuse assessment is for either SafeP or ISF followed by JCDI? Any input, Mr. Lewis or Ms. Malfino?
What Judge, in talking with my client, she's more than willing to comply with whatever help that the community supervision department can give to her, especially when dealing with the mental health issues, which I think that's what kind of leads to a lot of the substance use problems that she's had. And she's straightforward and honest with them during the evaluation. So Judge, I mean, whatever the court deems appropriate, she's more than willing to comply.
Let me just. I guess I'm trying to decide if. The substance abuse evaluation is very confusing because it says he and his the whole time instead of her. So it, but we're talking about the correct person, I believe. It's just,
Right.
yeah. No. I don't know that, what I'm looking for is to see if it states in here if special needs safety would be appropriate. I don't know based on the diagnosis of depression and anxiety, if that is enough for that with, how does that determine? Do you know?
She would already have to be diagnosed in order to do the special.
I mean, there's a diagnosis, it looks like. Well, I say that. Have you actually been to,
No, ma'am.
you have not been actually diagnosed. That's just how you feel.
Yes, ma'am.
Okay.
This is the turning point. The judge has reviewed everything, her past, her mental health, and her substance issues, and instead of locking her, giving her a structured second chance. But make no mistake, probation like this is strict when mistake. And it's straight to prison for 10 years. Do you think she'll make it through?
I mean, I was diagnosed when I was a kid, but.
Right, but you haven't anything recently.
Yeah.
Okay.
No,
So, all right. Anything else then?
no.
No.
All right, Miss Julian, what I'm going to do, at this time, I'm going to find that you previously entered your plea of guilty and true freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building
Yes, ma'am.
and find those prior convictions true.
Yes, ma'am.
Sentence you in accordance with your agreement to a term of 10 years in prison, but that's going to be probated. You'll be on probation for 10 years. Because there was no restitution amount that was turned in, I am going to order that you pay a fine of $500
Yes, ma'am.
and that you follow all of the rules and conditions of probation.
Yes, ma'am.
One of those is going to be that you enter and successfully complete the substance abuse track of the ISF program.
Yes, ma'am.
And then when you're released from there, you will go through the outpatient JCDI program as your aftercare. I'm also going to ask probation when you are released to do a mental health evaluation. And if there's anything that you need, if you need to be on a specialized caseload at that point, they will put you on that to help you with any other issues that you're having. And so if you do everything that you're supposed to when you're on this probation, this is a great opportunity because for all practical purposes, your case here in court is over.
Right.
The other side of that, though, is if you violate any condition of probation
Yes, ma'am.
and you test positive, you don't show up
Right.
for whatever it
Yes.
is, then you
No
will be
exception.
back in here and you'll be looking at that 10-year sentence that you've already agreed to.
Yes, ma'am.
All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you waived your right to appeal.
Yes, ma'am.
I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Oh, okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. I've got to read this to you.
Okay.
Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. And I will sign a dismissal as soon as it comes through as part of that agreement and cause number 25, DCCR 1394.
Yes, ma'am.
All right, good luck to you, ma'am. You can go back with the bailiff, of course. Good morning. Are you April Smith?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is gonna plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today or detectives to ask them to bring those new cases. Believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just gonna go open to the court on the full range of punishment with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am, or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19, 33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions, May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True. True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them, that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm gonna make that change because,
The only reason I did that is because we had the agreement.
Oh,
with the new
Not
cases.
just file.
okay, so there is an
Not-
agreement,
right,
actually.
There is actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
And asked them to file them and they still.
Okay.
Did yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them, and that's part of that plea agreement. Which means no matter what I do within the range of punishment, which is but up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Thanks.
Raymond Sweet,
Good morning, Your
good
Honor.
morning.
First. He knows it's on video.
Now this is a decision the defendant just turned down a 25-year deal, which sounds huge, but here's the risk. If he goes to trial and loses, he could be facing up to 99 years or even life. That's a massive gamble. So let me ask you, would you take the deal or risk everything in court?
Good morning, you're Raymond Sweet.
Yes, ma'am.
And this is 25 DCCR 1531. Mr. Sweet is charged with burglary of a habitation with intent to commit another felony. And what is the announcement?
Judge, Mr. Sweet was tendered an offer of 25 years today, for today only. Mr. Sweet is habitual, so the 25 years would be minimum if he were found guilty of this crime, and 2 of the priors were proven up, but Mr. Sweet insists on a trial.
Okay, so y'all didn't sign a new rejection.
No.
No, that's okay. I'll just make a notation on this one. So, Mr. Sweet, you and I have gone through with counsel before what the possible consequences are if you go to trial. If you're found guilty and if your prior convictions are true, then the minimum punishment would be 25 years in prison, up to 99 years or life. Do you understand?
Yes, ma'am, but ma'am, see, this burglary habitation,
So here's the thing, the burglary of a habit, if you're not guilty, if you think you're not guilty of it, that's what a jury's for. All right. I don't need to hear any of the facts. I don't want you to say anything on the record that could potentially hurt you later. So I just want to make sure you understand what your consequences are or could be if you go to trial. If a jury finds you guilty, and if they find that those prior convictions are true, your minimum punishment is 25 years up to 99 years or life. Do you understand?
yes, ma'am.
And the state has made an offer today, if you wanted to plead guilty for a 25-year term in prison. Again, you have every right to reject that and go to trial. And is that what you want to do?
Yes, ma'am.
And is there any reason to believe that any offer would change or?
It's only going up, Judge.
Okay, so there's nothing you're waiting on. All the evidence has been turned
Statute will
over.
go next week.
All right, so Mr. Sweet, I will get your case set for trial at the first possible trial date. Mr. Vasquez will begin preparation for trial and will not accept this plea agreement after today. You understand?
Okay, ma'am, I ain't got nothing to lose. Mother did, I don't have nothing to lose.
All right, go ahead and go back with the bailiff.
Thank you, Judge.
Thank you. Ms. Holmes, you have a Brianne Williams?
Yes, sure. That one, we may not, well, you can bring yours.
Brianne Williams.
Oh, her.
Good morning.
Good morning.
Brienne, it's not, it's.
Ms. French, this is Brianne Williams. It was a TRN and now there's a new thing that's popping up about fees and yes, I love that. Good morning. Are you Brianne Deshawn Williams?
Yes, ma'am. Good morning.
And this is 18-30512. Ms. Williams has a motion to revoke her probation. What is the announcement?
Your Honor, the district attorney's office is showing she has a case received. It's a 2024 offense date, but it's been received. And it appears she had a previous hearing back in 2024, which I think that offense may have been addressed, but it's just now getting to the DA's office to possibly be indicted.
Okay,
Based on the dates, I would agree with Ms. Holmes that the 11/19/24 admin hearing addressed that.
okay.
But there have been delays with the lab. So I'm not surprised that it's just coming around, but it is received and the state would like to have an opportunity to review that once indicted.
All right, so
before-
we'll just do one normal reset. That way, obviously, if there's another case, you can get it all taken care of at the same time. Ms. Holmes will get all of that information from Ms. French and she'll be out there to visit with you, go over what your options are. And then we'll see where we are at that next court date, okay? All right, you can go back to the bailiff.
Thank you.